Good morning, and may I thank Shaurya and his team at Think India for inviting me to the Think India Law Summit. Unfortunately, I'm unable to join you in Delhi on this occasion, as I've begun as Vice Chancellor at the National Law School of India University in Bangalore last week. So while the challenging first few days at this new role keep me away from Delhi and joining you at this panel, they give me fresh perspectives on the topic of our panel, the future of legal education in India. My greetings to Senior Advocate Mr. Vinay Navre and Mr. Rahul Chaudhary, National Co-Convener Think India, and fellow panelists. I look forward to hearing your presentations and the discussion to follow either remotely or soon after on the internet. In my 10 to 12 minute presentation, I want to explore the impact of the draft new education policy on legal education. For decades, legal education has fallen between two stools. The Union Ministry of Human Resources that does not see legal education as its primary or significant responsibility, and the Bar Council of India that does seek regulatory control but has no financial resources to support the development of legal education. In this vacuum, the National Law University experiment has unfolded. Initially, it was supported by the Bar Council, state governments, and legal academics, but recent avatars are primarily driven by state governments, the judiciary, and legal academics. I'm sure Rahul Chaudhary, as an NLU student, will reflect on his experience at these NLUs as they currently function. For my part, I'm going to look ahead at the future. The draft National Education Policy 2019, produced by the Ministry of Human Resources and Development, makes some fresh, bold proposals about higher education in general and legal education in particular. I want to focus on this policy for the reason that it promises that the ministry, the union ministry, hereafter will take a more serious interest in legal education, which may have as much of a transformative impact as the emergence of the NLUs 30 years ago. The NEP is divided into two parts, and I want to follow both these sections. First, on liberal education in higher education generally, and second, on professional education, particularly legal education. So just bear with me as I take you through the approaches to these two parts in the national education policy before I conclude. So those familiar with the national education policy already know that the policy pushes for a strong liberal education. Now, this phrasing, liberal education, is relatively new in India, but quite familiar outside. Para 11.1 of the policy states, the overall transformation of undergraduate education shall entail institutions offering courses and programs across the humanities and arts, social, physical, and life sciences, mathematics, and sports, alongside vocational and professional fields. It imagines a program organized along two lines: a common core curriculum and one or two areas of specialization that we normally call majors. In, Interestingly, the push for a liberal education extends in the national education policy to professional education. One might have thought that liberal education is for undergraduate colleges, whereas professional education must be done differently. That's not how the NEP is framed. It talks about transforming professional education and single field programs like the NLUs, arguably, in this way. The large number of professional education and single field programs across the country should over time morph into full-fledged liberal education programs, offering the entire range of majors and minors. During the transition, and for those higher education institutions which choose to continue to be focused on professional programs, and I take it that includes the NLUs, the curriculum shall integrate strong elements of other disciplines and fields, including humanities, social sciences, and arts in order to develop important attributes of scientific temper as well as creative and innovative thinking, close quotes. So the important first point to register is that the NEP anticipates a liberal education that extends to professional fields and single field institutions like the NLUs. So how does this affect the NLUs? And let me suggest a few salient points that we can pick up. First, the 5-year NLU model has often been misunderstood by students, parents, and sometimes teachers as a single field, single faculty institution. The liberal aspects, ignoring the fact that the NLUs offer dual degrees, either a BA or a BSc LLB, has meant that the liberal aspects of the degree, the BA part of the degree, are ignored at great loss to students. If the draft NEP is a guide, then all the NLUs have to morph into full-fledged liberal education programs. This must mean that the first part of your degree, BA, BSc, or BCom, will have to gain in importance, gain in breadth and depth. In my last week at NLSIU, I've already begun mapping some initiatives that we can undertake even this year to begin this transition envisaged by the new education policy. For example, to require creative physical expression, fine arts, and theatre as a part of the curricular offering would be a positive step in this direction. However, the fuller transition would require significant resources and planning, and I envisage that the ministry might take the initial steps in this direction. The second part of the NEP that deals with legal education is titled Professional Legal Education, and I quote from para 16.7, a key aspect of governance systems is the ability of the state and private interests to adhere to constitutional values and establish, support, and maintain the rule of law as envisioned in our founding documents. Legal education is visualized as a public rather than a private good, wherein the state, society, and markets have distinct interests and reasonable expectations related to their contribution to inclusive and equitable development. This phrasing is rather complicated, but let me point out that the important feature that I want to stress on is the clear enunciation that legal education must focus on constitutional values as well as the maintenance of the rule of law. Now, these constitutional values and the rule of law will in turn lead to a society progressing to an inclusive and equitable development, but the primary focus of legal education must be rooted in these values. Now, restoring legal education as a public good requires a concern with the maintenance of constitutional values through public and private institutions, but also the resources that ensure that legal education is neither too expensive and remains accessible to the vast majority of this country's population. Currently, institutions, most NLUs for sure, are either too close to the market or are too beholden to the state. Creating vibrant independent institutions requires some state support, but very far-sighted stewardship by the bar and the judiciary to ensure that the rule of law can be maintained. This is a formidable challenge, and frankly, one that has not been very clearly articulated in previous legal education policy. And this is a fresh and bold proposal that we must take seriously. The second element of the new education policy on legal education is to stress that we must have a curriculum rooted in the social and cultural context of our society. In order to transmit the foundational values, and I'm quoting, of Indian democracy to learners, in order to give legal studies the necessary social relevance and acceptability, the law curriculum has to fall back upon the culture and traditions of the people. How do we learn, you might ask, the foundational values of Indian democracy in a manner that is rooted in the culture and traditions of the people? Too often, this debate is trapped in a binary between whether we should use classical or modern sources of learning. It as a teacher in the classroom, as someone in charge of developing curriculum and delivering a program, I don't I don't place too much stress on this binary. I think we can learn very well from classical sources, medieval sources, modern sources of politics, literature, and history to enhance what it means to practice constitutional values in a modern democracy. What is important is not just the sources of materials that we use, but that we adopt an active and critical pedagogy. We must ask hard questions of our classics, of our modern history, of our literature. And so long as we educate our students to do this on a consistent basis, we can't go wrong. The third aspect of the NEP's focus on new education policy seems to be the most challenging, and this is the requirement that legal education be a multilingual education. State institutions, and I'm quoting, offering a law education must consider offering bilingual education for future lawyers and judges in English and in the language of the state in which the law program is situated. This is a significant and bold proposal, but faces some strong constraints. Legal education in India and legal scholarship in India, for the most part, is not bilingual. Far less is it multilingual. Significant exceptions exist, like Professor Faizan Mustafa at Nalsar, who is fluent in both Hindi and in English and maybe other languages. But these are few and far between. In the absence of contemporary multilingual legal traditions, we can only aspire to achieve this over the medium to long term. We can make investments today that will bear fruit in years to come. For example, compulsory requirements with respect to language instruction in all the NLUs. This is something that I would think about and take very seriously, but this is yet to become an everyday practice. All things considered, so I've taken you through two parts of the national education policy insofar as it has a bearing on legal education. The first part deals with a liberal education in higher education, and the second part deals with the approach to professional legal education and transforming these single faculty universities like the NLUs into a large multidisciplinary university. As you can tell by my presentation so far, I am excited by the draft national education policy. It infuses new energy and dynamism into a sterile debate in legal education that has focused primarily on whether we should have a 3-year program or a 5-year program. This is a relevant question, but ducks the core issues that we have dealt with. If we push in the direction of a liberal legal education rooted in our constitutional values, cultures, and languages, we can be sure that the professionals we educate will make a significant contribution to a progressive India in the 21st century. This is the primary purpose for which the national law universities were set up, and hopefully the draft national education policy will herald a new second wave of investment and reform in Indian legal education. Thank you.